Welcome to Just Theory. In this episode, we are speaking with Salomé Viljoen, an assistant professor of law at the University of Michigan Law School, where she studies the information economy, particularly data about people and the automated systems that are trained on such data. Salomé is interested in how information law structures inequality and how alternative legal arrangements might address that inequality. In this episode, we discuss a concept of privacy, creating a cohesive data framework, and legal interests in a data landscape. Without further ado, we now present you episode 4 on the legal constitution of social data. Salome, welcome to our podcast. We're delighted to have you here. We were hoping that we could maybe start, as we usually do, with a simple question of how you ended up in academia, why you chose a career in academia, and why you've decided to stay.
Yeah, thank you so much for having me. It's a pleasure to be here. People always say that the story of your life is just sort of like a retroactive narrative that you slap on to a bunch of random choices. And that's maybe true, but I think part of me always was very drawn to the kind of academic way of interrogating certain problems. And so in that sense, perhaps it was inevitable, but really, I started in undergrad thinking that I was going to become an economist, and then I went and got a master's degree in economics from the London School of Economics, and realized that like kind of the best part of my day was not the hours that I spent cleaning my data set only to run regressions that were breaking, but when at the pub afterwards, people would ask me like, what is the problem you're trying to intervene? And I could talk about like the social policy and the advocacy and the intervention I was trying to make with my research, which was on health outcomes. So from there, I sort of found my way to law, and in law, certainly in the US legal landscape or US law school, I kind of realized like I really liked being trained as a lawyer, which I sort of would analogize to like tennis. It's like you get trained in like how to like return a serve and like understand like the best angles on which to like send the ball like whipping in the other direction. And I liked that a lot. But I found myself sort of more drawn to like what I would say is like, rather than being like, okay, here's the best angle of attack, I would think like, why is the court this shape? Like, why is the line over here? Like, why is the net as high as it is? And that to me really are like the more academic questions. If a lawyer's job is to say the point I'm making is well established in law, it's really just a tiny deviation. The point of an academic is to really try to understand what are the rules of this game, what are their sort of basic foundations, what sort of principles or sort of social ends are they serving, and which ones might we serve otherwise by sort of rethinking some of those first base questions. So it was really to do that I ended up in academia. Why I chose to stay. I had a year of practice. It was extremely valuable for me in terms of my research, and I actually enjoyed practice. But again, serving clients is, you always have to put their needs first and their sort of articulation and priorities first. And I really like being able to interrogate my own problems and my own questions. And they tend to not be the questions of, is this lawful or is this not lawful, but why is the law the way that it is? And very few clients are interested in that question. But a lot of academics are interested in that question. And then I guess why I chose to, sort of a related point on why I chose to stay. I mean, I think in part I chose to stay because I was incredibly lucky to land an excellent job here at the University of Michigan, which is where I am. My partner is also an academic, so dual academic landing spot for us here. And if you're lucky enough to get it, I think it's the best job in the world.
We couldn't agree more, really.
Yeah.
Especially if you've got the passion for theoretical questions. Academia is
the only way to truly explore them, and the fact that you actually do have some practical background against that, I'm sure this is a great advantage. But what is really interesting from what you just said, and from what we've seen with our speakers before, is that academic trajectory is never, so to say, the only and first choice. So our guests typically have some mixed experience with, as you mentioned, in your case, economic interests and economic background, and some practical background. So we are delighted to have curious individuals with trajectories which are not necessarily straightforward.
And a lot of sporting metaphors as well, or like just involvement in sport, which is
It's
super
the Australian
cool.
Open right now, so I'm like in the
I
mode,
think last time we had some swimming pools as well, if I remember correctly.
Okay, nice.
I think two of our guests had a choice of a career being like really passionate about swimming, and this is what got them into academia. So
oh my gosh.
Yeah.
But just taking this back to academia and more academic and theoretical questions that we're most interested about in this podcast, we had a great privilege of reading your work in progress, Privacy and the Legal Constitution of Social Data, a paper which focuses largely on privacy data in a commercial context, and which unfolds, or your arguments unfold against two recent privacy cases. I was wondering, for the benefit of our audience, would you be able to tell us more about the paper? What inspired you to write the paper? What's the key claims in this article, and how did you go about engaging with those theoretical questions in privacy and the legal constitution of social data?
Yeah. So the paper was really inspired by some of my I really see it as kind of like a follow-on piece from some of my prior work on social data, which is just a term I use to describe data about people, because I think very little data about people is actually personal data. I think a great deal of it is actually social data. So that's where that term comes from. And the arguments here really are an extension or an application of some of the initial theoretical work that I did in a prior piece on a relational theory of data and data governance, where I'm really trying to articulate an account of the legal interests we have in social data as highly relational and not sort of reducible to individual choices and individual legal interests. So this piece is really just trying to apply that kind of theoretical work to these two, as you mentioned, recent cases in the US, recent privacy cases in the US context, to kind of understand the disconnect between the accounts of privacy interests being put forward in these cases and my own theoretical account, and really trying to point out kind of the dangers of not thinking about the legal interests we have in social data as social interests. And so that's kind of what inspired the paper, is saying like, look, I could actually use this theory to like evaluate live cases. Legal Academy. So that's the attempt. Sorry, did you want to say?
No, I didn't mean to interrupt, but
no,
I did actually. I didn't mean to interrupt. So what I was curious about, or what is prominent in the paper, is on the one hand this commitment or search for doctrinal purity, certainty within the notion of privacy as such. And then on the other hand, there are competing demands, obviously commercial demands, that public policy demands, or even simply corrective interests or corrective interests that are at stake here. So my question really is, again, going back to this pursuit of doctrinal purity or internal coherence, how important do you think it is for privacy to be internally, doctrinally coherent versus in light of other demands that life simply imposes on privacy law. I had some ideas of how can this be potentially conceptualized to preserve the purity of privacy, so to say, that doctrinal. But I will perhaps come back to this in a moment, and I'm very curious to know what you think of my proposal.
Yeah, I'm excited. I'm excited to hear this proposal.
But I was
perhaps, yeah.
I don't think it's that exciting, but I was just curious to know first how important it is for you to see this field as internally coherent, as doctrinally compelling, as opposed to other, and also respond to other interests, like, again, commercial interests, or simply an interest in responding to deserving claims irrespective of internal coherence or internal clarity.
Yeah, that's a really interesting read on some of the arguments. Just for context, for people who haven't read the piece, I tend to be, I'm quite critical of two recent privacy cases in the piece. One is by the ACLU suing the city of Los Angeles for imposing a licensing regime on scooters and e-bikes that involves transfer of location data in order to effectuate some of the enforcement mechanisms of the licensing regime. And the other is in the city of New York, a municipal regulation to require food delivery apps like DoorDash and Uber Eats. I don't know how international the reach of those are, but they're everywhere in New York City. Require them to share access to certain consumer information, customer information with the underlying restaurants fulfilling the order. And in both of these cases, privacy advocates have been extremely critical of these forms of regulation. So in part, what the paper explores is whether or not the camps of people who think, no, we need to regulate, it is in fact good for privacy that the government is regulating these entities, and the camps of people who say it is bad that the government is regulating these entities for privacy, how we can hold them both inside of the doctrinal and sort of conceptual categories of privacy. And Emilia, I think as your question hints, I think I tend to be a bit skeptical of our capacity to hold both of those claims inside of the doctrinal category or conceptual category of what a privacy interest is and what its protection or enactment in law might look like. And it's a really interesting point. I suppose I'm open to some internal pluralism inside of a concept, but I wonder, I think in part why I chose these cases is that they seem to me not just different, but in fact opposed, deeply opposed on certain key dimensions. So while I'm maybe okay with some internal incoherence, some plurality, are there certain positions at which we say the intuition or the articulation of what it is that we protect when we're protecting privacy is just so different inside of these two camps that they cannot coexist inside of the same kind of legal concept. I'm still sort of working. I'm open to being convinced otherwise. I'd love to hear your attempt to, but I think, right, I don't know. I teach contracts. I just taught a contract can be indefinite a little bit, but at a certain point, it's so indefinite, we can't gap fill anymore, and then it fails. And I think I'm sort of have a similar intuition here. Like privacy can contain many concepts and interests, and it always has. But at a certain point, are we trying to stuff so much inside of the category that we have instances of where the intuitions are just actually opposite, at which point something has to be inside and outside.
I think both cases you chose illustrate the tension very well and illustrate why this is problematic, why privacy interests are indeed problematic, because both cases involve really third parties, commercial entities, so to say, piggybacking on private interests of ordinary people, ordinary individuals, in order to potentially advance their own commercial interests, or in the name of those data protection, they are pursuing a claim almost relying on someone else's third-party rights and entitlements to bring or to protect their own interests. So one key question which emerges from this: whose data are we actually protecting? On who's the owner of the data? Who's got the standing? Is it only the person whose privacy has been actually adversely affected, or perhaps is it a third party, like commercial entity, who acts to protect the rights of their consumers in this case? Is it even conceptually coherent for someone who does not owe the right, whose right has not been infringed, to act on behalf of those third parties? I think this is something seen very often in privacy here in the UK as well, or in England and Wales. We've got a number of cases which involve this blurring or conceptual blurring in terms of who owns the data and who has standing. You've got celebrities bringing cases in the name of their children, for example, in order to protect their privacy, because it's easier for someone who's not a public figure to have a successful claim. Or there is a claim like Gulati case, Gulati litigation, which involved tabloids entering voicemails of famous celebrities. The question arises, whose data it is. Is it the data? Does the data belong simply to the person whose mobile phone you broke into? But voicemail is typically about someone else, yet another person who's recording information about themselves. So this blurring of who the data belongs to and whose privacy right are we actually invoking, who's got the standing, is something very controversial. And I noticed this in the two cases that you engage with as well, that the problem of piggybacking or third parties trying to rely on your or average consumer privacy right.
And also what's interesting, I think, just to follow through with this, maybe the confusion is about the concept of ownership and treating data as an asset class. And I know that this is also something that you touch upon in your paper. But this is this has been an ongoing debate for so long. This has been pre-GDPR. And it's a very similar,
it's a zombie debate. just like never dies.
Exactly. Yeah. And I think the language around it is not doing us any favor. Because using data in this context as another asset class is injecting a lot of confusion. And I guess this is again the point around this cohesion of the system and a cohesion of the doctrine that we are trying to apply here. So I would be very curious to hear what your response to this very elaborate question from both interviewers is going to be.
So on the point of outstanding, kind of like third parties using the privacy interest of another party to articulate some sort of claim, and in both of the examples that I use, sort of like an anti-regulatory claim, like against the state. I think that's what's really interesting, or what I'm really trying to understand in these cases, because one answer you can have for that is just to say, and as scholars in the US have, is just to say, like, well, that's a bad faith marshaling of the privacy interest, because Uber doesn't really care about the privacy of its riders. They just don't want the city of Los Angeles to regulate them. Or, Uber Eats doesn't really care about the privacy of customers. They just don't want New York to regulate them. And that's true. But another thing that I'm sort of trying to do in these cases is to show that prominent privacy advocate, like principled privacy actors, are also agreeing with these companies. So you have the ACLU in the case of Los Angeles actually being the one to sue the city of Los Angeles on behalf of this licensing scheme. And in the city of New York, you have testimony from the hearing by the Electronic Frontier Foundation and local anti-surveillance groups that are being excerpted in the complaints of Uber Eats and DoorDash as they're sort of making this claim. So what I find really interesting is that one answer that's provided, Emilia, to your question of these like third parties marshaling the privacy interests of other people just being kind of like a bad faith move, doesn't apply to the ACLU or the EFF. So something else is going on here. It's not just a strategic marshaling of the concept to me, or that's evidence to me that this is not just strategic marshaling of the concept, that there's like a deeper conceptual theory of what privacy is that aligns these principled actors and these commercial actors in making these kinds of anti-regulatory claims. And I think, you know, I'm speaking to a larger literature in the United States that really looks at what happens when we index all of our sort of non-commercial claims as civil libertarian or expressive claims, and how that really limits our capacity to understand the political economy in which those claims are being marshaled. Because one potential answer is that these principled actors do believe that the non-commercial interest in data, the privacy interest, is this kind of like core civil libertarian expressive interest. That's all that it is. But that sort of account of what the legal interests are in social data, what the privacy interests are in social data, is very conducive to companies then sort of standing as the third parties and being able to marshal very convincing principled claims against government regulation, which is not, at the end of the day, a civil libertarian government in position, but just like a core economic regulatory imposition. And so I really see this as, in the privacy context, us starting to make conceptual moves towards what has happened in the United States with First Amendment and free expression law, where when everything becomes an expressive interest, including things like money, companies can use the free expression protection to kind of erode and undercut and gut a lot of forms of economic and commercial activity regulation. And so if you're only indexing your privacy interests in that mode, or, you know, I actually do think that is what a privacy interest is. But if you're only indexing the like non-commercial human interests, social interests in data as that kind of expressive interest, you are articulating an account of what those interests are that is extremely conducive to companies then kind of encasing their commercial claims in that language and using that to kind of undercut a lot of economic regulation. That's like a move we've seen in the US before. And so that's part of what I'm trying to like stop and intervene and be like, I'm asking questions. I'm just asking some questions about this, whether or not this is the only sorts of interest that we want to give people in social data, because it seems to set us on this pathway that the US legal system is like very good at doing. And that seems like a bad path for us to go on if we're interested in actually regulating the information economy. And Aleksandra, I think that's like related to the question that you were asking about. I think we're particularly susceptible to that kind of set of moves when we really get hung up on whose interest is being expressed here. And so when we get really hung up on what is the privacy interest of the underlying customer in the restaurant delivery situation, or what is the interest of the underlying scooter user who might reasonably be re-identified from the location information that the city of Los Angeles is using, it looks like a privacy interest. And I'm cognizant of that. But that is completely distinct from the interest that the companies have in developing systems of mass commercial data extraction, which is not about you as an individual customer or you as an individual scooter rider, but really is this sort of social value that we have in mass at-scale data extraction. So when we're asking those sorts of questions in allocating who has a legal claim or a legal interest and what that means in terms of which regulations are appropriate or inappropriate, and we end up completely putting to one side the actual political economy that drives a lot of this data extraction to begin with, which is why I think these questions of ownership can just, I mean, it's why it's like the thing that I grappled with in my first paper entirely, because it's just, a red herring in some sense. It's like the wrong conversation to be having about social interests in data if we actually want to get at the point at which a lot of these harms or the risk of harm is occurring, which is why information about us is so valuable to begin with. And I think what I find really interesting about these two cases is that they show that even though you can have this intuition that mass surveillance in the commercial sphere is bad, when you end up focusing on these sorts of individual interests, you can sort of walk your way into advocating for a legal interest or a legal right or a legal entitlement that only strengthens that political economy. Because I sort of circling back to that sort of standing or third-party case example, what ends up happening if the ACLU is successful in their Ninth Circuit appeal? They lost at the district court, they've appealed to the Ninth Circuit, in constitutionalizing a right to location data. What ends up happening is that we've gutted the capacity for us to use that information to do like public transit planning for the city of Los Angeles, because they would have to get a warrant for all of that, which is insane. They were not going to do it. We've gutted their capacity to meaningfully regulate the terms of enforcement for rideshare companies. So as a result, we've massively, it looks like a win, like we've strengthened the expressive interest for underlying consumers, but we've also, as a result, massively strengthened the commercial position because they are now sort of shielded from government intervention in this entire realm of private ordering and private data extraction. We've sort of undercut the capacity for us to meaningfully regulate that industry and meaningfully regulate the ways that they are engaged in a lot of data extraction. So that's sort of exactly the interrelationship between that kind of conceptual set of that obsessive question of like, whose interest is this, the individual ownership question of this data, and this sort of story of encasement of commercial interests in civil libertarian or sort of expressive interest, which is like a standard move in the US. That's exactly sort of the kind of entanglements that I'm interested in exploring in the piece.
So what's interesting for me is that in a lot of the conversations to do with big data, emerging tech, especially now to do with AI, we are trying to use privacy as instead of ethics.
Yeah.
So instead of relying on ethical principles, we are trying to find some kind of heads of claim that would fit what we already have in place, even though very frequently, and maybe it's just a thing with common law that we've always struggled with, is that, we design certain principles for the past when the future is arriving faster than we anticipated. So that to me was incredibly interesting, looking at privacy from a more, as you said, political economy angle. But another thing that you talk about is also you touch on the concept of dignity in the meantime. So if you don't mind, I would like to read a single passage from your paper. You say that commodified social data reduces complex moral agents to flattened commercial products. In addition, the production of commercial data products facilitates other actions that violate our data subjects' dignity. So for me, the question is there an inherent relationship between privacy and dignity, or values such as dignity? And how does law fit within this landscape? Because what I'm thinking about is, how did we arrive at privacy coming from concerns that are either deeply moral or ethical?
Yeah, I think it's a great question. So I think different people would disagree about this, but I think there's actually quite a strong basis to say that my own view on this, which clearly I think is well founded in the theoretical literature, because it's my view, is that privacy is really like a predicate or instrumental ethical good or moral kind of good that is in service of securing individual dignity. So it really is about preserving that capacity for sufficient self-formation that we need in order to sort of understand ourselves as moral agents, and at the same time kind of preventing other entities from kind of entering sort of a sanctified sphere of self, and kind of undermining or negating or challenging that fundamental notion that I deserve to be the captain of my own my own destiny. And it's a profoundly it's in service of kind of that like dignitarian conception of who we are and what relation we ought to be granted to the broader world that privacy functions in to me. So I actually think of it, that's like a sort of normative account of privacy. Where that intersects, I think, or I actually see that as very closely, I think that that's like a very useful account to make sense of the kinds of laws we see and the kinds of sort of like legal tools that we associate with privacy. So the traditional focus on like really strong, meaningful, robust consent requirements, right, in privacy really is about like shoring up that barrier between like myself, my interior self that I like need to formulate my own mind, and as I like to say, like have a privileged relationship with myself, and the outside world. Like the reason we have that preoccupation in privacy is exactly for this sort of dignitarian conception and the kinds of post-consent rights, right? Like inalienable rights that we tend to think of as core data protection rights, I think are also nicely explained by this sort of close relationship with a dignitarian or dignitarian account of privacy, which is really, again, focused on downstream uses of information about me that can manipulate me, that can undermine my will. And yeah, I think that that's like very much at the core of what privacy is about.
Sorry.
Sure, yeah, go ahead,
If I may sound a kind of skeptical note, both in relation to your original response about bad faith and privacy pretexts, what you've mentioned before, as being irrelevant, so to say, to the force of the argument that you're trying to make, but also as a somewhat skeptical note about whether privacy interests have in practice indeed been those dignitary interests. So as far as the first point goes, you've mentioned that this is the fact that some commercial companies will use those third parties' interests to advance their own goals is, so to say, irrelevant because the upshot, the side effect is, or the benefit overall for the protection of rights is greater anyway. Because other interest groups confirm that this is valuable for the protection of privacy interest in the long term. I'm just worried about granting this capacity for commercial entities to rely on those third-party rights to advance whatever interest they want to advance, irrespective of what those interests actually are. Because in practice, when you're dealing with privacy as an ordinary person, let's say, those interests can be used against yourself sometimes. One example is with Amazon. If you want to challenge Amazon transaction you had, and the Amazon is not responding to you the way you wanted to, and you wish to bring the dispute outside of Amazon and contact a watchdog or an ombudsman, the response that you will receive, or the ombudsman or the watchdog will receive, is that we are not going to respond to this claim because it was sent from the account which is not associated with our Amazon account. So pretty much in UK, you have no chance of progressing or taking a claim outside of Amazon, because in the name of your own privacy, they will not accept claims being sent from ombudsman or from a watchdog saying, oh, this is not an email that is associated with the person's account. We cannot possibly even respond to this. So this is just example of how the privacy interest is sometimes used against the individual who holds the interest.
Exactly. I mean, I think, sorry, go ahead. Yeah.
And just briefly to touch upon the second point about dignitary nature of privacy rights. Professor Mallender, who works here at Newcastle University, he made a point that historically, at least in England and Wales context in the UK, privacy law was almost like privileged right. Only those who have enough interest and money would historically bring privacy claims. So those celebrities, they will obtain unprecedented compensation in terms of damages volume.
Yeah.
And the ordinary person, like a person in, let's say, the claimant in the Wainwright case, which involved strip search being conducted in breach of internal prison regulations, their claim was rejected, and they were told this is not a typical claim that would involve privacy invasion. So very often you have a handful of cases that are actually being brought by ordinary citizens here in the UK. It's a privileged terrain. It's a terrain that is, so to say, employed by those who do have money. I don't say that they don't have dignitary interests. They do, but there seems to be some kind of privileged dimension to it. And obviously, the two cases you've mentioned, the e-scooter case and the restaurants case, again involves large corporations benefiting or riding on those dignitary interests, which is almost a paradox here.
Yeah.
But hold on, just one point of difference that I'm hearing is that when we're talking about privacy, in the context of a single individual suing for what we would consider just a breach of privacy in what I would call a traditional sense, so wiretapped phones, right? Should this be treated differently than a breach of privacy that could be considered under an amalgamated data set? Because when we are talking about big corporates, this is an amalgamated data set. So it's not that you're necessarily you can be distinguished from any other data input on the spreadsheet. It doesn't have any distinctive characteristics of you as a human being. So are these two completely different? Or are these two similar because the principle is the same?
Yeah. Well, you've stolen my proposal. I'll come back to the proposals.
Yeah. So I'll engage with those in order. So I think that, Emilia, what you're touching on is like one potential response that happens like inside of the doctrine of privacy, which is to say, well, the problem here isn't that that there's sort of a conceptual blinkering when we only focus on privacy interests as the only non-commercial interest we have in data. The problem is just that we're not sort of like taking the right approach here. If we were to actually ask customers, like, does it like bother you from a privacy perspective more that like Uber Eats has this like large amalgamation of your data, or that the underlying restaurant, in order to be able to get around the completely predatory fees that Uber Eats charges them in order to just advertise food delivery to you directly, like, do you think of that as a privacy violation? And maybe a lot of people would say no. And their response to the like privacy traditionally being a privileged thing is to say, well, that's not a problem with privacy. That's like, we need to tell more people, like, you have privacy interests. You should be advocating for them and protecting them. And I suppose I am a privacy scholar. I think people do have privacy interests. I just don't think that category contains every single interest that people might have that is a non-commercial interest, and that they might have an interest in seeing enacted or enforced in the world. And so that's kind of my measured view, which kind of, Aleksandra, I think gets to your point, which is to say, I do think people have privacy interests in information about them. I think it is those uses of information that falls into the category of like personal data. So if information about me is being used to wrongly identify me, like misidentify me, or if it's being used to target me in some sort of other kind of wrongful or concerning way, that is like an individual use. That's like an individual data interest. I just think that we're using those same articulation of those interests to capture the amalgamated data set case, which is like the actual political economy that like makes it valuable for Uber Eats to collect all of this consumer data to begin with, and that also speaks to the commercial interest they have in not sharing that information with restaurants. Because if they share that information with restaurants, their business model, which relies on predatorily standing in between the restaurant industry and customers, goes away. And so sort of the aggregate amount of restaurant consumer information that they have is why they're able to sort of occupy that market position and squeeze a lot of money out of restaurants. And to understand that kind of commercial motivation, economic motivation, I think the sort of language of individual dignitary privacy interests of the underlying customers just doesn't get us very far, even though we can, in theory, like we can have the conversation of like, do consumers care more about a restaurant having this versus Uber Eats having it? Like, that's just like a separate, different conversation from the one of what do we do about profound amounts of economic and social power being concentrated in the hands of certain entities by standing in this role of sort of managing access to a social data resource. So that's the way I'm tying these two together. Aleksandra, you have a follow-up.
So that's actually, it's so spot on, because that goes to the heart of my question. So I'm not denying that there are privacy interests in amalgamated data sets. So but by no stretch of imagination. My only concern is that if we take a doctrine that was developed for a different purpose, so many of the cases that Emilia cited are very specific to individuals, and you can really pinpoint where exactly it is that your privacy was breached. Everybody can intuitively almost identify what's at stake there, right? Mm-hmm. And I wonder if it goes against, and correct me if I'm wrong, but I sense that this is a shared intuition in a way, that I wonder if extending that concept to those amalgamated data sets, to big data, is doing us, it's just not doing us any favors.
No, it's not doing us any favors.
Exactly. Yeah. So how would we develop a doctrine from privacy that would not be just an extension of the existing doctrine? So we don't enable the muddled landscape to be conducive of this kind of exploitation.
Perhaps.
Yeah. Sorry, go ahead, Emilia.
No,
that's Emilia's proposal now, isn't it?
No, I was thinking, as the conversation goes on, I'm less and less convinced about my own proposal. It's not that much of a particularly inventive proposal, but I wonder if this could even be done within the US jurisdiction as opposed to our jurisdiction. So there seems to be a dividing or two parallel developments here in the UK. One is the incremental extension of common law privacy from misuse of breach of confidence, then misuse of private information, which responds to traditional tortious, so to say, demands, like the demand for harm. So you need to demonstrate that you suffered some
have to demonstrate harm,
like
tough for privacy cases,
misused in some way. This has been, so to say, removed in the US with the intrusion upon seclusion, where a pure intrusion will already constitute invasion of privacy. And there is also data protection legislation, which seems to be responding and driving on a single controlling device, so to say, to use Fleming's phrase. So in data protection, there seems to be consent, or consent is the threshold. If you didn't provide a consent, that constitutes a breach of data protection. Whereas in common law privacy, you've got other controlling devices like the harm requirement, or you have to be the owner of the information, although this is being blurred now following cases like Gulati case, for example, or third parties cases. So I wonder if we could try to distinguish between a separate common law action that is governed by different devices and different controlling mechanisms, as opposed to data protection legislative intervention, which is governed by yet another form of controlling devices like consent, let's say. So this way we kind of preserve, to some extent, this internal coherence or doctrinal clarity within those two bodies of law. At the same time, I'm also immediately skeptical about it, because Thomas Bennett, for example, he emphasized that like restricting artificially this field could result in deserving claims being left, or meritorious claims being left without a response that they actually deserve. So an imposition of any artificial clarity devices will actually constrain deserving claims. So I don't know if trying to divide between, on the one hand, common law privacy interests and data protection, large amalgamation of data, so to say, as two separate categories would help at all.
Yeah, I mean, it's an interesting proposal. I mean, as a US legal scholar, those things are just not separated in the US at all. Or not at all, but generally not. We sort of think of them as the same. Privacy is the term we use to really capture both. But what's interesting is that in some sense, the data protection focus on consent for the large data set example is exactly like opposite. The interest being interested, or being that I'm interested in sort of capturing. I don't deny that there's maybe some privacy interest or some consent interest in whether or not you want your information to be amalgamated into a large data set, but a lot of the I think legally salient or legally relevant interests that are being implicated in how large at-scale data sets are processed and used do not reduce to any kind of consent. And so my quippy line about this, when I talk about this stuff all the time, is like, consent works because I'm consenting on my own behalf. If others consent on my behalf, that is not morally binding, and it is not generally legally binding. Again, teach contracts law. So consent as a legal mechanism does not work if I'm consenting on behalf of others and others are consenting on my behalf. But because of how, again, the political economy of data works, that is what's happening all the time, essentially fundamentally in the data economy. So that's just not the right legal mechanism to index my interests in large scale data processing. And, I would be a bad comparative law colleague if I didn't note that, people are always yelling at you as legal scholars, like, the GDPR is not just about consent. There are 6 legitimate bases for data processing. That is true. Consent is not the only legitimate basis for data processing. There are others. And I think that that's really what those sorts of other legitimate bases for data processing is trying to get at. Were it up to me, I think we would just get rid of consent entirely. It makes no sense. It does not index the interests that we're interested in indexing. I can't speak to the privacy landscape in the UK. I mean, it's right. You're right that it's interesting because of course, any sort of tort legal regime does not hinge on this question of consent. It looks at other kinds of threshold questions. And conceptually, I think that that's, for indexing those individual interests, still, I think, makes it, to me, attractive. Functionally in the US, we just have gutted our capacity to actually make use of a lot of those tort claims because we fail on questions of standing and privacy all the time. Basically, at the federal level, privacy standing is in very rough shape in the United States right now. You can still bring state claims, and people do, but it's increasingly difficult because we can't articulate a sufficient harm question. Purely informational harm oftentimes doesn't cut it for a lot of our torts. For some of them it does, so the intrusion upon seclusion, it does, but the application of those torts has been just very narrowed. And it doesn't capture a lot of the kind of digital privacy invasion questions that we're particularly interested in. And so that's, to me, that's not so much I don't have conceptual qualms with those torts. I have doctrinal, we've just really, really narrowed the scope of their application to the point that they almost become largely kind of these marginal appendages for us to actually enforce a lot of these a lot of these interests. But I think Aleksandra, to get to your kind of question about this, like that's about using sort of the nugget of these privacy interests to develop something that will get at these sort of large social data kind of concerns. As is probably clear from this conversation, I have real skepticism about whether or not we can do that from some of these kind of like core interests that we think of as privacy interests. I do think that personally, that privacy really does index that like dignitary individual claim that I have. I think those are real interests that we have in information. I just don't think that that is the primary interest that indexes this kind of like social data production problem. And so where we started this conversation of like doctrinal internalism, doctrinal breakage, I think there's a push in the United States, which I understand, because our intuition is that, as we sort of said, like our intuition for all of these ethical issues we have with big data is to call them a privacy problem, to call it a surveillance problem. And so there's a push to sort of stuff all of those concerns, problems of marginalization, problems of discrimination, problems of exploitation that happen digitally, into that conceptual bucket of privacy. And to sort of link those sort of moral and ethical concepts to the doctrine in order to develop an account of privacy that can capture those sorts of social data concerns, to sort of transform privacy into something that can really effectuate robust kind of substantive, so what we would say in the United States, like civil rights sorts of claims. And I just, I am skeptical about how far you can sort of pull that concept to account for those sorts of things, especially because I do think there are a lot of instances where like robust economic regulation of commercial entities points in exactly the opposite direction, or marshals an opposite set of legal intuitions from really, really robust civil libertarian protection, particularly in the context of US law. So I just think that sooner or later, we're going to like run up against a real wall of how much we can sort of stuff all of those other legal claims and interests inside of that doctrinal category for exactly that reason.
Emilia, I don't want to be a party pooper, but I think we are pretty much out of time now.
Oh, no.
Have you got one last question, or should we move on to the 5 questions that we have lined up?
Well, I don't have a question, just a disclaimer, because obviously my proposal was sounding so clear and prestigious, but obviously that's not the case about the UK privacy laws, and those distinctions and controlling devices, they do not work as in a clear-cut fashion as I just pictured them. And the same for consent. If you look at misuse of private information, which developed from breach of confidence, you've got your reasonable expectation of privacy, all of which could encapsulate all sorts of interests. So I try to kind of simplify it and simplify what we could potentially do. But if there is a piece of law or body of law that is in a state of complete disarray, I would rather say it will be the UK privacy law than the US. And we can learn a lot from you.
Credit. I'm like, maybe privacy law is doing great, and like the common privacy law is doing great in the UK. In the US, it's facing some trouble. But yeah.
So over to you, Aleksandra, and to our wrapping up questions.
Brilliant. Well, it's been a fascinating conversation, and we certainly look forward to seeing the paper develop further. One final remark from me, that the one question that didn't get to ask would be more about how regulatory compliance and cost of regulatory compliance would also impact the political economy of data generally. But that's a conversation for another time. For now, we have just 5 final questions for our bank. The first one is, who or what was your biggest inspiration in your career?
Okay. my 3L year, I took a course on technology and inequality with Yochai Benkler, who has been a wonderful mentor to me, was one of the people who, after the class, was like, have you thought about legal academia? So both his work in this area, as well as sort of his personal encouragement to believe in myself and my ideas, have to list Yochai as my gut answer there. I also met my husband in his class, so have a lot to have a lot of things to thank Yochai for. Yeah.
Amazing. What do you wish you could tell your graduate student self?
Oh, that's a good question. It's okay not to have all of those like markers of success that you think are like dispositive barriers against having an academic job. I think I showed up at law school already being like, well, the dream is dead. Like, didn't get like the Dean Scholar Award in every single class. And I don't also have a PhD in like philosophy. I could never become a legal academic. I should have finished my last essay so I could like actually apply to Yale. And yeah, I don't know. There's like all of these things that I thought were total barriers. But it turns out that the most important thing is having good ideas and being willing to write them down and edit them over and over and over again. And you can do that even if you haven't won the Dean Scholar Award in every single class or actually managed to finish your application to Yale Law School.
I think this is going to be our snippet for Twitter. I really want more people to be able to hear that, because that's not the narrative that's coming through a lot in a lot of academic employment, or when they prepare you in grad school for future employment. That's not the narrative that's being promoted. But if you could only read one book for the rest of your life, what would it be?
Wow. Fiction category, Middlemarch. Amazing. Nonfiction category, probably something by Jerry Cohen. I don't know which book, but some Jerry Cohen.
If you had not been an academic, what alternative career would you have chosen?
Wow, that's a good question. Fiction writer or professional organization consultant? Love
Amazing.
to organize.
Finish this sentence. One thing no one talks about in academia is.
One thing no one talks about in academia is how nice it is to finally have access to a faculty lounge.
This is amazing. I don't care. I mean, okay. This is honestly amazing. We had loads of like serious answers, but nobody's being pragmatic about it, and I just love the pragmatism. And Emilia, I'm sure
like like I have just endless access to like Perrier and Diet Coke. It's amazing.
This episode is not sponsored by Michigan, by the way. So just brilliant. Emilia, would you like to wrap up?
Well, Salome, thank you so much for joining us for this podcast. It was, I actually ended up with more questions now than I had.
Oh no,
than I had before, but it was incredibly enlightening and inspiring. There will be a point at which I will be teaching privacy here at Newcastle Law School, so I'm sure I will be citing the e-scooter case just to encourage our students to think outside of box, because these cases do not fit neatly with the complex landscape against which privacy constantly develops. So we're very grateful for your insights and for this paper in particular. I wish you best of luck with the publication, and do let us know once the paper is out.
And it will be added in the description of the episode. Thank you so much, Salome. It's been amazing.
Great. Thank you so much for having me. I had a wonderful time talking through some of these questions with you both, even if you left with more questions than answers. Such is the fate of thinking about social data and legal theory.
Success.
Thank you.
Hi, it's Aleksandra here. We hope you enjoyed this episode. If you like our project, have any questions, or would like to recommend a guest or a topic, drop us a line on just.theory.project@gmail.com. This season was made possible with the generous funding of Newcastle University. If you like, you can buy us a coffee. Your support will enable us to continue our work. Just Theory, changing the face of legal theory.